Hello, everyone. I am Jacob Stein, and welcome to this presentation on COVID-19, business and asset protection. I have been practicing asset protection planning for about 20 years. I represent clients around the world, ranging from the big names in Silicon Valley, Forbes 400 families, to mom and pop business owners. And in today's presentation, I would like to draw on my experience of doing this for the past 20 years to share with you what I think will happen in the coming recession and how we can move ahead in protecting our assets and planning ahead. So every listener, I'm sure, is aware of the fact that the recession is coming, right? Pretty much every single economist has now predicted it. It is expected, it is happening now. And why is it important? Why is it important from the standpoint of asset protection planning? Well, what happens in a recession is businesses fail or businesses are unable to meet their liabilities, to pay their expenses, to pay their rents, to make loan payments, and so forth. And often that leads to claims, that leads to lawsuits. Now, perhaps today, given what's happening today, that's maybe difficult to imagine because, for now we are all in this together, right? This is sort of the rallying cry that we are all hearing. We're all in this together. And what we're seeing so far is, if you're defaulting on your mortgage, the lender is not going to do anything in the meantime, right? They are forbearing from taking any sort of collection action. The courts are closed, nobody's filing lawsuits. Landlords are not evicting, at least they're not evicting residential tenants. So for now, it's all great, right? We're sort of in a pause environment. Eventually, that will come to an end, right? Eventually, the virus is not going to be the hottest thing on the news, right? People will get tired of it. It's going to fade from prominence. And all of a sudden, we will find ourselves in an environment where we're not in this together, right? We are in this separately. And everyone is now, again, looking out for their best interests, right? So society eventually will return to somewhat normal. People's behavior will revert to the mean. And what will happen is that all these lenders and landlords and everyone else who are owed money, who have claims against business owners, against individuals, will come trying to collect, right? Because everyone needs to pay their own bills. So it will happen. It's not happening yet, but it will happen. And we, in our practice, we have already been seeing this for the past 3 weeks, maybe even 4 weeks, of business owners of varying kinds of businesses reaching out to us, looking to protect assets because they do anticipate that at some point in time, collection actions, lawsuits will take place. And this is true of retailers, of restaurant owners. This is true of owners of commercial real estate, lenders, mortgage lenders, commercial lenders, and everyone else you can think of. In the past few weeks, we've already seen pretty much every vertical segment of the economy seeking asset protection planning in anticipation of what may happen later this year. So we have, gone through this previously. We represented quite a lot of clients following the 2008 recession. Again, every single industry and vertical segment you can think of. We've represented lots of real estate developers and builders. We've represented lots of owners of real estate, both commercial real estate and residential real estate, business owners of every stripe, you name it. So certainly everyone who signed a personal guarantee is now vulnerable in the coming recession, and that we and a lot of our clients have learned the hard way following 2008. So just off the top of my head, I will tell you that following the 2008 recession, we represented something like 300 real estate developers who at some point in time signed a personal guarantee on a loan, right, which we all do when things are going well. And then the lenders came knocking on their door trying to collect on those personal guarantees. And likely the same will happen at some point in time in this COVID recession. Lenders, landlord, disgruntled investors, disgruntled business partners, you name it, will come trying to collect because they want your money. So what are the lessons we've learned from 2008? Probably the most important lesson is that for this planning to be successful, for the asset protection planning to be successful, whether we're looking to protect the assets of your business or whether we're looking to protect your personal assets, the earlier you plan, the better. I guess the question is it still early now, or is it already too late because we're already in a recession, or we already are on notice, right, that things are not going well and there will be a recession and we will be unable at some point to make loan payments? Well, certainly it would have been better to engage in asset protection planning in January of this year as opposed to in April or May. But having said that, you're still better off engaging in asset protection planning before you default on a loan payment, before you default on a lease payment, because today, prior to default, the creditor is not going to have as easy of a time challenging the asset protection structures using the fraudulent transfer attack, which we will come back to in a few minutes and discuss in slightly more detail. So the earlier your clients plan, the better. The earlier you plan, the better. And then the other lesson is that we really do not know today how aggressively any particular creditor will come after our clients, right? So we've seen, again, hundreds and hundreds of clients just in the past recession, following the past recession. And often different clients will find themselves in an identical situation. Let's say there are two real estate developers, both are on the hook for a $5 million loan. Both of them signed a personal guarantee. Both of them have personal assets sufficient to cover this $5 million personal guarantee that they do not want to pay. And the only difference is that there are two different lenders holding that note. And one lender may choose to be very aggressive in how they pursue and collect on that note, right? They will file a lawsuit and they will fight and they will challenge what we've done, and they will search for assets. And they will just, go all out trying to collect on this $5 million note. And the other lender may do absolutely nothing, or the other lender may settle very quickly, for just a fraction of this $5 million and move on to their next case. Just sort of as a summary from what we've learned in the past recession is that when we are looking at lenders, certainly the big lenders, tend to be less aggressive. If you borrowed money from Bank of America, in our experience, they're not going to come collecting as aggressively as, let's say, some local, business bank or a community bank, or as aggressively as a private equity lender, for example. So you do need to know who is your lender and try to get a sense of how aggressively they will pursue your assets. And then outside of lenders, landlords do tend to pursue tenants fairly aggressively. And the rest, I think, in other cases, how aggressively a lender will pursue our client will depend on a host of factors. It will depend on how much money is at stake, right? The more at stake, the more it makes sense for the creditor to pursue the money aggressively. It may depend on the relationship between the creditor and the debtor. It may depend on whether the creditor sees any assets that are easy to take from the debtor. Is there any low-hanging fruit? And if there is low-hanging fruit, why not go after it and go after it aggressively? So what is it that we're trying to accomplish with an asset protection plan? In light of all of this, let's say later this year, in the depths of the recession, once people sort of start coming out of the stupor that this virus has induced, what is going to happen? Well, we will see creditors start filing lawsuits, right, to collect what is owed to them. And once they file lawsuits, some of them, having filed the lawsuit, will be able to place a lien on the debtor's assets right away, and some will have to wait until there is a judgment in place to be able to collect and lien on assets. We'll discuss that in a few minutes. But that's coming, right? The lawsuits are coming later this year. So given that it's coming later this year, what are the goals of asset protection planning? And I think, and this is probably a good time to clear up a couple of misconceptions. A lot of people associate asset protection planning either with hiding assets or with making assets unreachable. So let's briefly discuss each one because these are important topics. Is the goal of asset protection planning to hide assets? And the answer is no. The goal of asset protection planning is not to hide assets. Hiding assets is not a bad thing, right? It has its benefits, but it's not something we can rely upon substantively. Why is that? So let's say that our debtor engages in what I call the Home Depot method of asset protection planning. The Home Depot method of asset protection planning entails the debtor taking all of the assets that she owns, selling all of her assets, converting them into cash, then going to Home Depot, buying a shovel. Well, you can figure out the rest. Is that effective? Is that an effective way of protecting assets? Like, certainly a creditor cannot find where you buried that cash, right? Not possible. Sounds like it should be effective. But here is the remedy that is available to every creditor. Once the creditor has a judgment in place, the creditor can conduct what's known as a debtor's examination. And in the debtor's examination, the debtor has to answer questions under penalty of perjury. And what if one of the questions is something like, have you been to Home Depot recently? Now the debtor has to perjure himself for the hiding of assets to work as a means of protecting those assets. So in our practice, we do not rely on hiding of assets as a way of protecting them, but that does not mean that we shun hiding assets. So what is the distinction? The distinction is that it's great to hide assets because it does bring value to the table. Because if you do a good job of hiding assets, maybe that plaintiff, maybe that creditor will never file a lawsuit in the first place. And that we have seen lots of times. Right? Let's say, I have, for example, friends who are plaintiffs' attorneys, and they will sometimes call me and say, listen, we're thinking of bringing this lawsuit against the defendant. This is all we can find. Do you think there are other assets out there? Or do you think we'll be able to penetrate the structure that's in place? And the answer usually is, well, I have no way of knowing. You have no way of knowing until you try. Right? So now to the plaintiff's attorney, there is a lot of risk. Maybe there are no other assets out there. Maybe the simplest structure that's in place, which can be just a trust or an LLC, right? Something very innocuous and simple. Maybe it will work and they will not be able to reach the assets that are inside those structures, right? So for the plaintiff's attorney, all of a sudden there is a lot of risk in litigating this case, and perhaps they will choose not to pursue that case and go after something else, right? Where it will be easier to collect, where the assets are more visible. If our client is already in litigation, and we can go to the plaintiff's attorney and say, there are no assets here, and they cannot find them, right? Searching for them. Again, maybe now we're in a great position to settle that litigation. So hiding assets is not bad. It's just not something we can rely upon substantively. We want to do something substantive where we can argue that the assets no longer belong to our client, that there is a legal reason, not just a practical impossibility of getting at the assets or finding the assets, but there's like a legal barrier to the creditor's ability to reach the debtor's assets. We want substance, not just hiding. So that's number one. Number two, as I mentioned, a lot of times folks associate asset protection with making assets impossible to get at, like some sort of a bulletproof, silver bullet-like type of an asset protection plan. That's rarely in the cards. Rarely in the cards. There may be a couple of structures where we can tell our client, your assets are now unreachable. And even when we ever 100%, which is reachable. So let's say that's bulletproof. But these structures are the exception to the general rule. The vast majority of asset protection structures, and there are dozens of different structures that are used to protect assets, cannot come close to that level of protection, right? We cannot make assets unreachable. So if we cannot make assets unreachable, what is our goal? The goal for me in my practice is to make our clients' assets difficult and expensive to get at, not impossible. And that's really, I think, important to get, because often when we are discussing either with other lawyers or with our clients, the various structures that we would like to bring into play, there are sometimes objections that look something like, well, the structure is not perfect. I can see a creditor doing this or arguing that, or what about this or that? And the answer is like, well, yeah, the structure we are suggesting maybe is not perfect, but of all the options you have available, that's your best bet, right? So we're not looking for a perfect solution. We're not looking often for a perfectly protective solution. We're looking for what is the best available play here, right? So it's a very practical approach. What can we do to change the plaintiff's economic analysis of the case, to force them to walk away, to force them to settle with our client on terms that are acceptable to our client? So here's the interesting part. Here are the statistics that we have compiled over the past 20 years. So, having represented, 2,000 to 3,000 clients. Understand that we're not statisticians or mathematicians, we're lawyers, but it's a fairly large statistical sample. So I think these statistics are pretty accurate. So in about 30% of cases, when a creditor is confronted with an asset protection structure, whatever that structure may be, they choose to walk away. So here, a lesson from 2008 recession, I think will be very much on point in this coming recession. We had a client who decided to become a real estate developer. He had no experience being a real estate developer, no real estate background other than perhaps watching these home remodeling shows on HGTV. And he became a real estate developer by borrowing money from the bank on his mom's personal guarantee. So his mom personally guaranteed a $5 million loan from the bank. And the son became a real estate developer, I think in like 2007. And in 2009, he walked away from all of his projects. He had no assets of his own. He didn't really care. The lender knew that there was no recourse to go after him. They went after mom, right? Mom signed a $5 million personal guarantee. Mom had plenty of assets to cover that personal guarantee. We protected those assets. That lender decided not to pursue her. They took a look at the asset protection that we did, and I don't think it was anything magical, just common sense stuff. They decided not to pursue that case. They just dropped their $5 million claim, walked away. So we see that 30% of the time. Obviously, it's not a result that anyone can guarantee or promise. We do not know which client will fall into that 30% and which client will not. But that's a fairly promising result, this having the creditor walk away. Of the remaining 70% of cases, the vast majority of the time, I would say 95, 98% of the time, we will see the creditor settle with our client. A settlement that our client is happy with. And this is something that that we hear about most frequently. We just routinely get phone calls from our clients saying thank you, for the work you did a few years ago. What you set up for us ended up working, and we were able to settle in very favorable terms with our creditors, which is of course very encouraging to hear. And in maybe 2% of cases overall, we will see creditors continue to pursue our clients despite all the structures that we have set up, and they will try to penetrate and cast aside the structures that we have set up. And sometimes they are successful at that, and sometimes they're not successful at that. But if you look at our client pool as a statistics, in 2% of the cases will the creditor aggressively pursue our clients' assets that are inside an asset protection structure, sometimes successfully, sometimes not, right? So let's say 1% of the time, what we do does not work, meaning that 99% of the time, we are either forcing the creditor to walk away or forcing them to settle with our client on much more reasonable terms. So that's our goal. That's the goal of asset protection planning. And for me personally, I don't think that forcing the plaintiff to walk away is really a goal that we want. Why? Because even if the plaintiff sort of walks away, meaning they're not pursuing our client, like that mom with a $5 million guarantee, the creditor never came after her, but they did have a judgment against her, right? They had a $5 million judgment, probably plus interest and penalties and legal fees and what have you. The judgment doesn't go away, right? Depending on what state you're in, the judgment can have a fairly short duration. There are states where the judgment is enforceable for, let's say, 6 years. And there are states where a judgment is enforceable for 30 years. So for example, I live and practice in California. A fair amount of our clients are in California. So here judgments are enforceable for 30 years. That's pretty much a lifetime, right? So if the plaintiff does not choose to pursue our client, it doesn't mean the judgment just goes away, right? It just means they are not today taking an action on that judgment. But the judgment still sits out there, accrues interest. What if the plaintiff decides to pursue the judgment tomorrow? And think about how our client now has to live, right? He can never own assets in his name, because if there are assets in his name, maybe the judgment will attach. Maybe as soon as there are assets in his name, that's when the creditor will come back and decide to collect on that judgment. So I like to tell my clients that even if we can make your assets unreachable, that is likely not what you want. Take that, the fact that your assets are unreachable, and use that as a means of extracting a favorable settlement from the plaintiff. Pay them something, give them some incentive to walk away from you, right? And be done with it. Put it in the past and move on with your life. So what is possible and what is not possible? Pretty much anything is possible, right? So long as our client wants to do so. If our client wants to make assets unreachable, we can do that. Not every, because what if making assets unreachable means that you have to sell your real estate, convert it into cash, and move the cash overseas? So theoretically, we can make the client's estate, their net worth, unreachable. But practically, if they have, let's say, an emotional, psychological, what have you, attachment to their assets, and they're not willing to sell, then making those assets unreachable is not possible. So really, so much depends on our clients and what is it that they are willing to do to protect what they have. There are a couple dozen structures that we use to protect assets, and I guess that other practitioners use to protect assets. None of these structures are right or wrong, right? And this is a question that we get fairly frequently. What is the best way to protect my house, or what is the best way to protect my bank account? And the answer is, I don't know if there is such a thing as the best way. there are, different options of how to protect different types of assets. And for different types of clients, one option or another option would make more or less sense, right? So in our practice, we go through this analysis, these 4 factors, to determine, what are the structures that we should be considering. So we look at who is our client, who is the debtor. And really the most important inquiry here will be how risk averse is our client? What is the client willing to do to protect his assets? And again, different people are exactly that. They're different. And those same 2 real estate developers, for example, facing a personal guarantee default, or 2 doctor clients facing a malpractice claim, or 2 people who ran over a pedestrian, right, may choose to do very different things to protect the exact same assets. So it depends on how risk averse the client is, what is their budget appetite for legal work, how good is the defense counsel who is representing them in the lawsuit, and so forth. So this identity of the debtor greatly influences what it is that will be done to protect assets. And then there are certainly other kind of more technical questions. For example, is our client married or single? Because in some states, we can do very different planning for a married couple as opposed to a single person. Is our client an individual or a legal entity? If we are planning to protect the assets of a legal entity, the considerations that come into play are very different. Now maybe we're worried about successor liability, or sideway piercing of the corporate veil, or regular piercing of the corporate veil, and so forth. The next factor we will consider is the nature of the claim. And here, really, there are 2 important considerations. Generally, timing is the most important one, meaning when are we engaging in asset protection planning? Is it before something bad has happened, or is it after something bad has happened, right? Are we protecting assets before there's a loan default, or after? Are we protecting assets before a lawsuit has been filed, or after? Before a car accident, or after? And obviously, the earlier in time we can engage in asset protection planning, the higher the likelihood of success. And we'll talk about fraudulent transfers in a second, and I'll explain why that is. In a recession, a lot of the cases that we will see are cases where a prejudgment attachment is possible. What does that mean? So generally speaking, before a plaintiff can go after our client's assets, they need to file a lawsuit, obtain a judgment, and then using the judgment, they can go after our client's assets and either lien on some assets, levy on other assets, and so forth. But in some cases, they can obtain what's known as a prejudgment attachment. That's the ability to place a lien on the defendant's assets before a judgment is obtained for the purpose of securing those assets while the lawsuit is pending. A prejudgment attachment is available in a lawsuit that arises in a business setting where damages are easily ascertainable. And usually these are lawsuits by lenders for default, or lawsuits by landlords for default on the lease, right? So long as it's a lease of, let's say, business premises or industrial premises, or a loan default relating to a business loan, not a personal use loan. Because with leases and loans, the damages are fairly easily ascertainable, right? We know exactly what is owed to the lender. We know exactly what is owed to the landlord. So in a lot of these cases, prejudgment attachment is available, which means that the plaintiff can file a lawsuit, move for a prejudgment attachment, place a lien on the defendant's assets. I believe that lien, well, varies from state to state, but usually will stay in place for a couple of years. And that precludes the defendant from being able to do anything with his assets while the lawsuit is pending, meaning that we cannot help as soon as the prejudgment attachment is in place. So when we are talking to clients, especially in, right now in the recession, who are facing these claims from lenders and landlords and such, we're telling them you need to move very quickly, because as soon as the landlord or the lender file a lawsuit for default, they will move for a prejudgment attachment and you're done. So very, very quickly, we need to get assets out of your name so that this prejudgment attachment lien will not attach to your assets. Bankruptcy, an important consideration here. And bankruptcy and asset protection sort of go hand in hand in a sense, meaning that it's the same types of clients and the same types of circumstances that seek both to protect their assets and seek to file for bankruptcy protection. So first of all, how do you know whether you should go into bankruptcy or seek asset protection? There are a couple of factors that are involved, and I think probably the most important one will be, are there assets? If the debtor has assets, then filing bankruptcy is often not going to be that productive, because if it's, let's say, a Chapter 7, those assets will be liquidated, and then creditors will be paid, and so the assets are lost to the debtor. If it's a Chapter 11, let's say, then the assets maybe are not lost, but the creditors are sort of paid pretty much in full with the payment plan, right? If there are no assets, then bankruptcy may be perfect, right? Just discharge your debts and restart. But if there are significant assets, either in the business or their personal assets, asset protection planning may be the way to go, because this way, the assets are protected and are not made available to a creditor. The next factor we look at are the creditor's characteristics as a creditor, meaning how aggressively will this particular creditor pursue our client? Is this a creditor that's going to be aggressive or lazy, intelligent or dumb, knowledgeable about collection laws, not knowledgeable about collection laws? And this is just something that you only know through experience. Right? So often in seminars, when I ask folks, who do you think is the most aggressive creditor out there? What is the scariest creditor for us to go up against? The majority of people will say the IRS. And certainly the IRS is in the top 5 of scariest types of creditors, but it's not the top one. Ahead of the IRS will be other federal agencies like the FDA, the FTC, the SEC, much more aggressive than the IRS, much more ruthless than the IRS. And then certainly in number 1 position will be either a former spouse or a former business partner. Those are by far the most difficult creditors to go up against, because with creditors like that, it's not just about the money, right? With a former spouse or a former business partner, there's an emotional element to the case. They may just want to, make sure that our client has no assets left, even if they don't end up collecting anything. And with a creditor like that, making assets difficult or expensive to get at is not going to be enough. We either have to be able to make assets unreachable, or we don't bother trying at all. It's very important to know what kind of a creditor is pursuing our client. And then finally, and also hugely importantly, what are the specific assets we are looking to protect? Are we protecting bank accounts and brokerage accounts? Are we protecting commercial real estate? Are we protecting the client's personal residence? For most clients, probably their most valuable, most important asset. Are we protecting intellectual property, artwork, gold bullion buried in the backyard? What are the specific assets we're looking to protect? And here, various state law and bankruptcy law exemptions may come into play. For example, in some states, some meaningful amount of equity in your home is exempt from creditor claims. Varies from state to state. There are states where the homestead exemption is very low, like $35,000. There are 3 states where the homestead exemption has no dollar limitation, and the limitation is only placed on the size of the property, not on the value. There are exemptions available for different types of retirement plans. In some states, for example, only ERISA qualified plans will be exempt from creditor claims. And in some states, every type of retirement plan will be exempt, again, without a dollar limitation, and so on and so forth. So exemptions are usually very state specific. let's move on to fraudulent transfers. And I'm kind of keeping this title, fraudulent transfers, even though this has been now renamed into the Voidable Transfers Act. And I think that name voidable is a better, more appropriate description of what happens as a result of this type of a transfer. So the fundamental rule of collecting on the judgment that we are working with is that if the debtor owns an asset, as a general rule, the creditor can take it. You know, you get a judgment against somebody, you can pretty much take anything and everything that that person owns, unless an exemption applies, right? So maybe some amount of equity in the home is safe, maybe some types of retirement plans are safe, but by and large, anything and everything that a debtor owns, the creditor can go after. It's also true that if there's an asset that the debtor does not own, the creditor cannot take that asset from the debtor, right? So if there's a judgment against Jacob Stein, and Jacob Stein does not own the home that he lives in, Jacob Stein's creditor cannot take that home. It belongs to somebody else. So pretty much all of asset protection planning looks to take an asset that a debtor owns and make it into an asset that the debtor does not own. Well, if it's that simple, how is it that anyone can ever collect on a judgment, right? You're facing a possible judgment, just take all of the assets that you own, make them not yours. Transfer them to your sibling, transfer them to your kids, transfer them to a trust or an LLC or what have you. So to prevent that from happening and to allow creditors, to give creditors sort of a fighting chance on collecting on judgments, we have these fraudulent transfer or voidable transfer laws. And these laws have two ways for a creditor to attack a transfer of assets. The first one is a transfer with the intent, what's called actual intent, to hinder, delay, defraud a creditor. So we look at the intention behind the transfer. Why did the debtor sell everything that she owned and buried gold bullion in the backyard? What was the intention behind that action? Was the debtor worried about a possible lawsuit? Or was the debtor concerned about, the worldwide pandemic that is sweeping the globe, and was worried that we are going to slide into post-apocalyptic age and gold is going to be more valuable than anything else? Kind of a silly example, but how do we determine what is the person's intention behind what they do? So in the fraudulent transfer arena, that intent is determined through circumstantial evidence, right? We look at the circumstances surrounding the transfer of assets, what is known as badges of fraud. So for example, when did the debtor transfer assets, right? So if you transfer assets 2 days after you run over a troop of pedestrians, perhaps that's a badge of fraud, right? That can be indicative of your intention of why you transferred assets. Is that enough? Just because you transferred assets 2 days after you plowed into a group of pedestrians, does that mean that the reason you transferred assets is because of that accident? Perhaps not. Perhaps you've been in the process of implementing an estate plan for the past 2 months. And, today was the day that was scheduled for a while when the asset transfers will be completed. And 2 days ago, you happened to get into a car accident, right? So intention to transfer assets was formed prior to the accident taking place. I'm not going to go through all the badges of fraud and spend a lot of time on fraudulent transfers. That can be an entire hour-long seminar on its own. But let's stop here. So this intent and timing, these are important badges of fraud. The two other important badges of fraud look at whether the transfer is for fair market value, right? and also they look at whether the debtor is insolvent at the time of the transfer. So notice there is also a constructive fraud test for a fraudulent transfer. This, under the constructive fraud test, if the transfer is for less than fair market value, right, less than full consideration, and there is insolvency, meaning as a result or at the time of the transfer the debtor is insolvent, that's a fraudulent transfer, and it does not matter why the transfer took place, right? So that's a much easier way for a creditor to establish a fraudulent transfer. Transfer for less than full and fair market value and insolvency. The constructive fraud argument can only be raised by those creditors who had an existing claim against the debtor at the time of the transfer. So here timing becomes really critical. So if our client borrowed money from a bank and signed a personal guarantee, and if he has not yet defaulted on that loan, he's still current on his loan payments, and today he transfers his assets into an asset protection structure, the creditor cannot use constructive fraud. Okay, constructive fraud can only be used if there is a present claim that exists. And today the creditor has no present claim because the debtor is still current on the loan obligations. So if the debtor is still current on the loan obligations, the only way to establish a fraudulent transfer is to argue actual intent. And it's certainly possible to successfully argue actual intent. It certainly has been done many times, but that is a much more difficult way for a creditor to go than showing constructive fraud. So that's why timing is so important. Whenever possible, we want our clients to protect their assets before they default on that loan payment, before they default on that lease payment. You know, if that has already happened, it is what it is. We cannot go back in time and undo that, you know, and we will have to maybe engage in more robust asset protection planning, knowing that the creditor will now be able to argue both actual intent and constructive fraud to establish a fraudulent transfer, and we still may be very successful in our endeavors in protecting assets. But if possible, plan as early as we can. Now, what happens if the creditor does establish that the transfer is what is now called voidable, a voidable transfer? And the name, I think, kind of says it all. The transfer is voidable, meaning the creditor gets to set aside the transfer of assets, and they get to go after the transferee and recover the transferred assets. So I will tell you that pretty much every single client that we talk to, you know, one of the first questions that they ask us will be, can't I just transfer my assets to my kids? It's a sensible question. I mean, that's one of the most common sense questions to ask in this context. You know, the assets will go to the kids eventually anyway. We trust our kids a lot more than we trust anyone else. So certainly, why not transfer assets to the kids? Well, we do not want to transfer assets to the kids because that's probably the easiest type of transfer to attack as a fraudulent transfer. That's number one. And number two, a fraudulent transfer lawsuit is a lawsuit against the transferee, right? It's a lawsuit against the transferee, meaning that if you're okay with your kids being sued, then, you know, engage in this transfer. But if you do not want your kids being sued, then perhaps you do not want to transfer assets to them. That's why we want to transfer assets to sort of abstract structures like legal entities, trusts, and the like, so that we do not end up with an individual being sued for a fraudulent transfer. Let's move on to legal entities and talk a little bit about using legal entities to protect assets. So legal entities are very frequently used to protect assets from creditor claims. So I want to talk about how we can use an entity if an individual is being sued. And then I also want to talk about what do we do if the entity that we own is itself the subject of a lawsuit, which certainly in this economic climate is very likely, right? We may have an entity that borrowed money or an entity that's being sued by employees or what have you. Let's talk about both sets of circumstances and what we can do in those circumstances. So let's say our client owns some valuable real estate with a lot of equity, and the real estate is in his name. The client is driving down the street, runs over a troop of Girl Scouts. There are Thin Mint cookies all over the place, and he gets hit with a huge lawsuit. A judgment is entered against our client. And now the question is, can that plaintiff reach the real estate that is in the client's name? And the quick answer is yes, of course they can. Pretty much any asset that our client owns, the plaintiff can reach. What if the real estate is not owned by the client directly? What if that real estate is in a corporation? Can the plaintiff reach the real estate? Well, not in a direct way, because the real estate is not owned by our client, right? He's just a shareholder. It's owned by the corporation, which is a separate legal person. But the client owns something else. The client owns the shares of stock in the corporation. Shares of stock in a corporation are personal property and are reachable by the plaintiff. So the corporation really, in this example, does not help us that much. What about a limited liability company? Now the analysis changes a bit. Again, there's a judgment against the individual. The individual does not own the real estate. The individual owns a membership interest in a limited liability company. So once again, the plaintiff cannot go after the real estate directly. Can they go after the membership interest in the LLC? And the answer is no, they cannot. So state law, and this is true of pretty much every state, well, I think without exception, true of every state, a membership interest in a limited liability company is not subject to attachment by a creditor. The only two exceptions I'm aware of is Florida and Colorado, where if you have a single member limited liability company, then the LLC interest can be attached, similar to how a corporate interest can be attached. A corporate share can be attached. But those two states aside, and even in those states, if you have a multi-member LLC, you are protected. The membership interest in a limited liability company is not subject to attachment by a creditor. Same is true of partnerships. If you have an interest in a general partnership, or you have an interest in a limited partnership, or a limited liability partnership, like your law practice, a creditor cannot attach, cannot take from you your partnership interest in these partnership entities. So certainly we want to own our valuable assets, not directly, not through a corporation, but either through a limited liability company or often through a limited partnership. So that the asset that we own is now an asset that is not subject to attachment by creditors. There are certainly exceptions to these rules that we will not get into just because there's not enough time, but I do want to talk about one other aspect of planning with corporate entities. So very often what we will see is a lawsuit that is directed against the legal entity itself, because the legal entity is the operator, the owner of the business and its assets. So we represented, for example, recently a national tire chain. They were facing a $30 million product liability lawsuit. Or perhaps it was a negligence claim, something like that. Sorry, not top of mind right now. It was just $30 million claim against this national tire chain. And this national tire chain owned and operated locations all across the US. Some were owned by them. The real estate was owned. Most was leased real estate. They owned very valuable intellectual property from their trade name. They owned various domains that produced a lot of their e-commerce traffic. They owned lots of inventory, like millions of dollars of inventory, had millions of dollars in receivables. And all of this was in a single entity. So that same entity that operated each tire store across the country also owned all of these very valuable assets. And now we have, a lawsuit against this corporate entity. And obviously the lawsuit can reach all of the assets of that entity. This is a structure that we see often, and this is sort of an issue that we see often, where you have one legal entity that operates the business and owns all of the valuable assets. And usually you have the structure because when the business was initially established, this is the structure that made sense. Nobody wanted to spend time on, legal planning or setting up more legal entities. For a startup, money is better spent on other things. And then as the business became successful, nothing ever changed, right? They sort of were stuck with this inertia. What we like to see and what we like to do is a structure where we have more than one legal entity involved in the business. So we will have, let's say, this corporation continue to operate the chain of tire stores. So if tomorrow there is a product liability lawsuit, it's against the corporation. But this corporation no longer owns the intellectual property. This corporation perhaps no longer owns the inventory, right? The inventory is in a separate entity that is then consigned to the corporation. It certainly does not own real estate. So when there is a lawsuit against this corporation, it has as few assets as possible, because the fewer assets this corporation has, the greater the likelihood that we can extract a settlement from the plaintiff. Where this sort of planning with legal entities gets really difficult, in my experience, is when we do have this single entity that is being sued, and the client says, you know what, this is going to be a devastating lawsuit. We need to somehow walk away from this existing business, from this existing entity, and restart our operations in some different form. Can we just set up a new legal entity and restart operations in a new entity and just leave the existing liability in this entity? And the answer is that it's not that easy. There is a legal concept known as successor liability, and successor liability provides that if you set up a new entity and that new entity substantively is pretty much the same as your existing entity, then the liability of the existing entity will follow you into the new entity. Successor liability. One of the most important facets of successor liability, one of the most important factors to look at, is whether the ownership of the two entities is the same or different. So if we are going to set up a new entity and hopefully, hope that the liabilities will not follow us into this new entity, we have to make it look like the ownership is different. We want to try to create a business purpose. Why was this entity created? Perhaps the business that it will be engaging in is somewhat different than the business that the existing entity is created. We want to try to create some distinctions among who are the employees of the two entities, maybe their corporate address, website, phone number. That sometimes can be very intrusive on the business operations, but often there is no choice if we want to restart business operations in some new form and not have the existing liability reach us into the new entity. Let's talk about planning with trusts. And by the way, you've noticed probably that I'm skipping a slide here and there. This is actually a presentation that I often teach as a full day presentation over 8 hours. So obviously in the 90 minutes we cannot cover every slide, and the slides we're covering, I'm sort of giving you the most important highlights of that topic, and we're not able to explore it in this presentation in extreme depth. My hope from this presentation is that you will all walk away with the ability to spot issues with kind of a good fundamental understanding of the different structures that are used, how they work, what is possible, what is not possible. So at least you can start the conversation with your clients. And of course, anything that we either have covered or have not covered, but you wanted me to cover, you're always welcome to email me. You have my email address, you have my contact information. Email me, ask me questions. I'm always happy to answer questions. Okay, so trusts are very frequently used to protect assets. Recall that our primary exercise in asset protection planning is to take an asset that our client owns and make it into an asset that the client does not own. If you think about it, that's not difficult to do, right? Just take all of the assets that you own and donate them to the Salvation Army, and they will no longer be your assets. But of course, that's not what most people want to do, right? They want to make the assets legally, technically not their assets, but accomplish it in such a way so that they can actually retain control, retain the ability to transfer the assets back into their name. And they usually want to engage in these transfers of assets without any tax consequences. How do we do that? So the perfect structure to do that is actually a trust. Why a trust? Because with a trust, you do have something that's fairly unique, right? A trust is not a legal entity. A trust is a private contractual agreement between the settlor, the person who's setting up the trust, and the trustee of the trust. And because it is a private contractual agreement, by and large, the terms of this contract are entirely up to us. So long as we're not looking to do something that is illegal or would be void as against public policy, we can structure a trust in pretty much any way we want to. We all have certain sort of preconceptions of how trusts work, especially how irrevocable trusts work. And it turns out that, with asset protection, the only trust that can be helpful is an irrevocable trust. Because if the trust is revocable, every state law allows plaintiffs just to go directly after the assets of the trust that is irrevocable. So every asset protection trust is irrevocable, and that is disconcerting for most people. Because if the trust is irrevocable, it suggests to many of us that we've lost control, right? If the trust is irrevocable, we've lost control over the assets that we have placed into the trust. We have lost the ability to get our assets back, right? It's sort of a done deal. And that's very difficult to commit to, right? Because maybe today we need to protect assets, but tomorrow that need may pass. Tomorrow we have the financial means of placing assets into an irrevocable trust. And tomorrow there is a worldwide pandemic and fortunes change, and now we need to regain access to our assets, right? Today there is an estate tax and we want assets in an irrevocable trust, and tomorrow the estate tax is gone for whatever reason, we want the assets back out. So it turns out that the reason that we associate irrevocable trusts with something that is cast in stone, that is immutable and changeable, that requires a commitment, is because that's how irrevocable trusts have been drafted for the past, 400 years or so. About 10 years ago, that started to change. We started drafting irrevocable trusts in a very different way. So let me explain how and why, because I think that's, first of all, interesting, but second, important to get. So first of all, how do we know that a trust is irrevocable? And once a trust is irrevocable, what specifically does that mean? Well, we know that a trust is irrevocable if somewhere in the trust agreement it says so. If the trust does not speak to whether it's irrevocable or irrevocable, by state law, it is always revocable. So there has to be some specific statement in the trust that says this trust is irrevocable. And for centuries, when an irrevocable trust was drafted, it would actually say exactly that. This trust is irrevocable. So let's look at what that means and what does the state law require for a trust to be deemed irrevocable. And perhaps let's start with that first. For a trust to be deemed irrevocable under the law of your state, the person setting up the trust cannot have the ability to get his assets back. That's it. That's all that revocable refers to. There's nothing to do with the ability to amend the trust or to terminate the trust. It's just about the settlor's ability, power to get his assets back. So irrevocable versus irrevocable technically does not describe the trust. It describes the transfer of the assets to the trust. Is the transfer of the assets to the trust revocable or irrevocable? So if it's irrevocable, it means the settlor has transferred assets into the trust and cannot reverse that transfer. He cannot get his assets back. So notice that the definition of what is irrevocable is fairly narrow, right? doesn't talk about whether the trust can be terminated, doesn't talk about whether the trust can be amended. It doesn't preclude other people from returning the assets to the settlor. It just specifically says that the settlor cannot have the power to get his assets back. Traditionally, these trusts have been drafted to say this trust is irrevocable, and it cannot be amended, and it cannot be terminated. Just by tradition, those things were put together because at some point in time early on, that was the goal for the trust. You know, we wanted these irrevocable spendthrift trusts where the beneficiaries would have zero control over the trust. Today, especially when we are setting up lifetime trusts, right, what are called intra vivos trusts, where our client is still alive and the trust will be functioning during his life, he may want to retain the ability to terminate the trust when he wants to. He may want to retain the ability to get his assets back. He may want to retain the ability to make changes to the trust. But from an asset protection standpoint, the trust must be deemed irrevocable. So how do we reconcile this? Well, so starting about 10 years ago, the way we draft irrevocable trusts has changed. A lot of lawyers, us included, have abandoned the traditional drafting that has this global prohibition, right, that says this trust is irrevocable. Because when it says that this trust is irrevocable, no one can revoke it. Certainly the settlor cannot, he's included in that, but so is everyone else on this planet. And that has changed to say that the settlor does not have the right to revoke the trust. The settlor does not have the power to get his assets back. Because if we limit it just to the settlor, if we only prohibit the settlor from getting his assets back, who can? Perhaps someone else can, right? So nowadays we will say the settlor cannot revoke the trust, but then we will appoint someone else, someone who is independent of the settlor, who will be given the power to return the assets to the settlor. And this person is commonly referred to as the trust protector. Today, when we are drafting an irrevocable trust, we will no longer say that the trust cannot be amended. Now, the settlor of the trust cannot have the power to amend it. But why not give this power to someone else? So, so today, when we draft irrevocable trust, or the more modern practice of drafting irrevocable trust, is to include in the trust the concept of the trust protector. The trust protector is a new position that's been created within the trust regime. This is in addition to the trustee, and the trust protector is given certain very broad, usually non-fiduciary powers over the trust. So the protector does not control the assets of the trust on a day-to-day basis. He does not hold title to the assets of the trust. The trustee still holds title, but the protector is given certain broad strategic powers. The protector may be given the power to revoke the trust, meaning return the assets to the settlor. The protector may be given the power to terminate the trust, meaning accelerate the distribution of the assets to the trust beneficiaries. The protector may be given the power to amend the trust in a limited way or in a wholesale way. The protector may be given the power to change the trustee of the trust, to change the beneficiaries of the trust, the tax treatment of the trust, the governing law of the trust. He may be able to force the distributions. He may be able to veto distributions. The only power that the settlor retains, our client, the debtor retains with respect to the trust, is the power to remove and replace the protector. Now, the settlor can never make himself the protector of the trust, because then all of the powers of the protector will be immediately attributed to the settlor, and the trust will be treated like any irrevocable trust is treated, so there is zero protection. But so long as the settlor cannot appoint himself or someone who will be deemed an agent of the settlor, the trust works. We have asset protection. And effectively, from a practical standpoint, certainly the settlor has a large degree of control over the trust. So, you know, this concept of the trust protector has been a wonderful development in the world of drafting trusts. And I will tell you that in the past 10 years, I don't recall if I've drafted any irrevocable trusts, and I've drafted hundreds of them over the past 10 years, that did not include the trust protector. So what do we use a trust for, a revocable trust? Well, they can be used for any asset, similar how, let's say, an LLC can be used to hold any asset. But here is the distinction. I believe that the irrevocable trust is a stronger form of protection. Why? I'll give you another example. We had a client, an elderly gentleman who was involved in a car accident. Fortunately, nobody was injured seriously, but there were several people who were injured, let's say lightly to moderately. He had, decent insurance coverage, but the plaintiff filed a lawsuit far in excess. They wanted, I think, like $1.5 million in excess of his insurance coverage. He had, our client had a primary asset was a residence that was worth a few $1 million. And while in the course of litigation, the residence was transferred to an irrevocable trust. And then later on, a financial statement, the declaration of assets was submitted to the plaintiff. And this declaration of assets showed that our client, the defendant, had no assets other than his Social Security check. And the plaintiff literally that same day settled the case for, I think, something like $50,000, which our client was very, very happy with. Now, why was this possible and how was this possible? Well, this was possible because the ownership of the house was transferred to an irrevocable trust. And it's only possible with an irrevocable trust. It would never have been possible with an LLC. So if we transferred the ownership of that house to a limited liability company, there still would be an asset on the financial statement, right? The membership interest in the LLC that has significant value. And perhaps the plaintiff would not have settled the case, right? But having transferred the ownership of the residence to the irrevocable trust, our client no longer owned that asset. It now was the property of the irrevocable trust, allowing him to truthfully fill out a declaration of assets. You do have to know, your creditors, meaning that if we tried to do this, let's say, with a bank, it likely would have never worked because the bank, being an intelligent creditor, having experience in these matters, would have inquired about recent transfers of assets, right? And then we would have had to disclose that the house was recently transferred to the irrevocable trust, and perhaps the bank would have either chosen to challenge that or they would have pushed for a much higher settlement. But the plaintiff's law firm did not ask those questions. They relied on the declaration of assets, and we got a great result. Only possible with the irrevocable trust because the asset entirely comes off the financial statement. Now, for some of our clients, this is difficult to do because the asset comes off the financial statement. So if our clients, are still trying to qualify for bank loans, they're real estate investors, developers, what have you, this is difficult to do because once the assets are in the irrevocable trust, it's not on their personal financial statement. They may have a difficult time getting loans. So this needs to be balanced. How do we decide when to use an LLC and when to use an irrevocable trust? I think often that depends on the types of assets we are working with. Just a very quick example. If we're working with income-producing real estate, let's say it's an apartment building, and the client needs the cash flow that's being generated by the apartment building, usually we will place the apartment building into an LLC, even though that affords somewhat less protection than the trust. When the apartment building is placed in an LLC, the client still can easily access the cash flow because he's the member of the LLC and the LLC can make distributions to him. With the irrevocable trust, our client is never the beneficiary of the trust. It's always someone else. I do not believe in self-settled trusts, which I'm not going to get into right now. I think that in practice, trusts set up for the benefit of a third party like kids work much, much better. But because our client is not the beneficiary of the trust, we cannot make distributions to him. And with cash flowing assets, it just doesn't work well if the client needs access to the cash. But something, let's say, like a personal residence, there is no cash flow. Doesn't really matter to the client who holds title to the residence. So an irrevocable trust is perfectly suited. In the few minutes that we have left, let's talk a bit about offshore trusts. And offshore trusts really deserve sort of their own spotlight. At the beginning of the presentation, I mentioned that there are structures where we can tell a client that your assets are not protected with about 99% certainty. And one of the structures that are commonly used to accomplish that result would be in a revocable offshore trust or some other form of an offshore structure, because there are other types of offshore structures, but irrevocable offshore trust being the most common one. So why is it that an offshore structure affords us such a high degree of protection? First of all, I will tell you from my personal experience in the 20 years I've been doing this, I have never seen any plaintiff or any creditor pursue assets in an offshore structure. And we handle primarily very high stakes cases. A lot of money, usually millions of dollars at stake, clients who are very high profile, like politicians, celebrities, big well-known families, and often, creditors who are very aggressive, big government agencies, big plaintiffs' law firms, banks, private equity funds, you name it. And I've yet to see any creditor pursue assets in an offshore structure. Now, I realize that it happens. And I realize that tomorrow can be the first time that it happens to one of my clients. We're not doing something that is kind of super magical. It's just the odds of that happening are extremely remote. Why? First of all, it's the structure itself, right? And it's often the fact that the structure is overseas, meaning that a US court does not have jurisdiction over the title holder of the assets, right? The title holder of the assets is some sort of an offshore structure, a trust, a private foundation, a company, a multi-trust structure, or what have you. And it's not someone in the United States that they can force to take an action. And number two, in a properly implemented offshore structure, the assets are overseas, right? If the assets are still in the United States, the US court retains jurisdiction over the assets. And the judge may not care who owns those assets, right? He may say, I don't care that you transferred the ownership of your house to an offshore trust. I'm just going to sign a judicial deed and transfer the ownership of the house to the creditor. So if we are setting up an offshore structure, we are only doing that if the client will be transferring wealth overseas. And the only type of wealth that they can transfer overseas will be liquid wealth, right? You cannot transfer real estate offshore. We do not have a shovel large enough for that. So we use offshore structures for clients who are facing some sort of, bet the farm type litigation, where we know that the plaintiff is going to be very aggressive. We really, really need to protect assets and make them pretty much unreachable. So there are some jurisdictions that have optimized their laws to favor debtors and make it really difficult for creditors to collect. The three, I guess, for us, the three preferred jurisdictions over the years have been the Cook Islands, St. Vincent, Nevis, but we've used numerous other jurisdictions for various purposes in Europe and Asia, other Caribbean jurisdictions, and so forth. And then the money needs to go outside the United States. Our preference usually is to send the money to a bank in Europe. So, I'm not somebody who thinks that an offshore structure is some sort of a silver bullet for what ails you. But when the client needs to have a very strong level of protection, if they really want to be able to sleep well at night, knowing that their assets are unreachable and untouchable, this really is, in my experience, the way to go. But it is a difficult decision to make. If, let's say, the primary asset that our client owns is his personal residence, right? The only way to get that offshore is to sell the residence, pack up everything that they have, move into a rental and move cash overseas. And for so many of our clients, that's just a really difficult choice to make. First, you need to pack, you need to uproot your kids. There may be income tax consequences from the sale. You really love the house you live in and so forth. But understand that if you are facing a very determined and aggressive plaintiff, they don't care that this is your home. To them, it's just an asset that can and will be sold to satisfy the judgment. And once that home is sold at a judicial foreclosure, you still have to move and pack and have income tax consequences from the sale and uproot your kids and so forth. So I would rather have my clients sell themselves today and keep the equity, keep the sale proceeds, than be forced to sell tomorrow and lose it all. There are lots of different offshore structures. There are lots of different domestic structures, right? I do not believe that any of these are right or wrong. There is no perfect structure. There is no perfect way of protecting assets. It is all about common sense. To me, it's all about common sense. What can we do to make it difficult enough, to make it expensive enough, to change the plaintiff's economic analysis of the case, to either force them to walk away or to force them to accept a settlement, right? It's just basic common sense. And, with this COVID recession that we are in now, and that's just starting, and who knows how bad it will be, hopefully not so bad, but you will see some clients having to make difficult choices. You will see some clients who are not able to pay their vendors, pay their landlords, pay their banks. And if that is the case, perhaps asset protection is something that they need to consider. I am always happy to answer questions from anyone who has taken my presentations. All you need to do is shoot me an email. You're welcome to call me, and I will always be happy to answer your questions. I am Jacob Stein, and thank you for listening to this presentation on COVID-19 business and asset protection planning. Have a great day.